You've got a bank account right now that could be costing you $12,000 every single year in benefits, maybe more. And here's the terrifying part. 70% of retirees have this exact account and have no idea it's disqualifying them from programs they desperately need. I'm not talking about some offshore account or anything illegal. I'm talking about a regular savings account, a joint checking account, maybe even a life insurance policy you bought 30 years ago and forgot about. Go check your bank app right now, because what I'm about to tell you could change your entire retirement. Let me explain how this works, because the government doesn't exactly advertise this information. When you apply for Medicaid, especially for nursing home care, most states have an asset limit of $2,000. That's it. If you have $2,001, you're disqualified. You could have worked for 45 years, paid taxes your entire life, and because you saved a tiny bit extra, you get nothing. Supplemental Nutrition Assistance Program benefits, what used to be called food stamps, have similar limits. In many states, if you're a senior household, you can't have more than $4,250 in countable resources. Go over that, and you're denied help buying groceries. Supplemental Security Income requires you to stay under $2,000 in assets if you're single, $3,000 if you're married. Cross that line by even $1, and your monthly check disappears. But here's where it gets insane. It's not just money you can access easily. It's money you might not even remember you have. It's accounts with other people's names on them. It's assets you can't touch without penalties. The government counts it all, and one wrong account can disqualify you from benefits worth thousands of dollars every month. Joint accounts with your adult children are the #1 killer. You added your daughter to your checking account 10 years ago because you wanted someone to pay bills if you got sick. Smart move for convenience. Financial disaster for benefits. The state looks at that account and counts every penny as yours, even if half the money is your daughter's paycheck. That old $401,000 from a job you left in 1998. It counts. You might have $8,000 sitting in an account you haven't thought about in decades. You can't touch it without penalties and taxes. But Medicaid doesn't care. It's a countable asset. Whole life insurance policies with cash value are a trap people fall into constantly. You've been paying premiums for 40 years. The death benefit is $50,000, but the cash surrender value is $12,000. That $12,000 counts against your asset limit. You can't access it without canceling the policy, but the state counts it anyway. Savings bonds your parents bought you when you were a kid. If they're still in your name and they've matured, that's countable. A second home, even if it's a tiny cabin in the woods you never visit, that's countable unless it's your primary residence. A rental property bringing in $400 a month. Not only countable, but that rental income affects your eligibility too. People are getting disqualified from life-saving benefits because of assets they forgot existed or didn't think mattered. Let me tell you about Margaret. She's 71, lives in Ohio, and her health started declining fast last year. She needs nursing home care. The cost, about $7,500 per month in her area. Her Social Security check is $1,850. She can't afford the care she needs, so she applied for Medicaid. Margaret thought she was safe. She had $1,400 in her checking account, under the $2,000 limit. She'd spent down her savings over the years, living off it to supplement her Social Security. She was careful. She qualified, or so she thought. But here's what she didn't realize. 10 years ago, she opened a joint savings account with her daughter, Emily. Emily lived 3 states away, and Margaret wanted her to have access to money in case of an emergency. Made perfect sense. That account had $15,000 in it. Emily had been depositing money there too, saving for her own future. Medicaid looked at that account and counted all $15,000 as Margaret's asset. It didn't matter that Emily deposited most of it. It didn't matter that Margaret never touched it. Joint account means the state assumes it's all hers. Margaret was denied. Benefits worth $6,000 per month. Gone. She was told she needed to spend down to $2,000 before reapplying. That means draining $14,400 from that joint account. Emily's money. Emily's savings. Gone. Just to qualify Margaret for benefits she desperately needed. Margaret called me in tears. She felt like she'd destroyed her daughter's financial security. Emily insisted they spend it down, that her mom's health was more important. But watching your child sacrifice their savings because of a decision you made a decade ago, that kind of guilt is crushing. This is the trap that catches people over and over. You added your kids to your account for convenience, for emergencies, to avoid probate. It seemed responsible. Every estate planning article tells you to do it. But those articles don't mention the benefit disqualification that comes with it. Here's how the states see it. If your name is on the account, they count 100% of the balance as yours. Your son deposited his paycheck. Doesn't matter. Your daughter's been saving her money there. Doesn't matter. You're listed as a joint owner, so they assume you have full access to every penny, and they count it against you. I've seen people with $50,000 in joint accounts with adult children get denied benefits. The parent had $500 of their own money in there. The rest belonged to their kids. Didn't matter. Disqualified. Even worse, some states use a presumption that the money is the applicant's, unless proven otherwise. You have to provide documentation showing your child deposited the money, that it was their earnings, that you never touched it. Try gathering bank statements from 10 years ago. Try proving which deposits were whose. It's a nightmare, and most people can't do it successfully. One account, opened with good intentions, destroys eligibility for benefits that could be worth $70,000, $80,000, even $100,000 per year. So what do? How do you fix this before it costs you everything? First, remove your kids from joint accounts immediately. If you need someone to access your account in an emergency, set up a power of attorney instead. A POA gives them legal authority to manage your finances without making the account jointly owned. The money stays yours, and only yours, for Medicaid purposes. But here's the critical warning. Don't just move money around randomly. Medicaid has a 5-year look-back period. If you transfer assets to your kids, or anyone else within 5 years of applying for Medicaid, you'll face a penalty period, where you're ineligible for benefits. The penalty is calculated based on how much you had transferred. Give away $50,000. You might be ineligible for 8 months, even if you desperately need care. So transfers need to be strategic and done as early as possible. If you're healthy and think you might need Medicaid in 10 years, now is the time to move assets. If you're already declining and might need care soon, transfers could hurt you. Instead, convert countable assets into exempt ones. Your primary home is exempt in most states, no matter the value. Put money into home improvements, fix the roof, renovate the bathroom, upgrade the kitchen. You're improving your living situation and converting countable cash into an exempt asset. Your car is exempt, up to a certain value in most states. If you're driving a 15-year-old sedan, buy a newer, safer vehicle. That's countable cash turned into an exempt asset. Prepaying funeral and burial expenses is explicitly allowed. Most states let you prepay an irrevocable funeral plan with no dollar limit. That's money you'll need to spend anyway, and putting it into a funeral plan removes it from your countable assets. You can prepay for yourself and your spouse. I've seen people legally shelter $20,000 this way. Setting up certain types of trusts can protect assets, but this is extremely complicated. Irrevocable trusts can shield money from Medicaid's asset test, but you lose control of that money. You can't access it, change the terms, or get it back. And again, the 5-year look-back applies. Set up a trust this year, apply for Medicaid next year, you're penalized. But set it up now for care you might need in 2030. You could be protected. This is where you need an elder law attorney, not just any lawyer. Elder law attorneys specialize in Medicaid planning. They know the rules, the exemptions, the strategies. A good one can help you restructure your finances legally to preserve assets while qualifying for benefits. Yes, it costs money up front, but it can save you tens or hundreds of thousands. Some people look at Medicaid-compliant annuities. These convert countable assets into an income stream that meets Medicaid's rules. You're essentially trading a lump sum for monthly payments. It's complex, and it's not right for everyone. But in certain situations, it protects assets while maintaining eligibility. Here's what you need to understand. The rules around Medicaid, SSI, and other benefit programs are designed to help people who have nothing. If you have anything, even a modest amount, you're expected to spend it all before the government steps in. That's the system. It's harsh, it's unforgiving, and it catches people off guard every single day. But you don't have to be one of them. Check your accounts right now. Joint accounts, old retirement plans, life insurance policies, savings bonds. Make a list of everything you own. Then talk to someone who understands the rules before you need benefits. Not after you've been denied. Because once you're denied, your options shrink. You're scrambling, making rush decisions, spending down assets in ways that don't benefit you. But if you plan ahead, even just a year or two, you can protect what you've built while still getting the help you need. Margaret eventually qualified for Medicaid, but only after spending down that $15,000. Emily lost her savings. Margaret got the care she needed, but the cost was devastating to her family. That didn't have to happen. If they'd known 5 years earlier, they could have restructured everything legally and protected that money. Don't let a bank account you opened for convenience cost you $12,000, $50,000, or more in benefits. Take action today, because tomorrow might be too late.